Okay, it looks like we are live streaming and we are recording. So we're going to go ahead and I will convene this evidentiary hearing. My name is Andrew French. I'm chair of the Kansas Corporation Commission, serving as presiding officer for this hearing. And I'm joined by my fellow commissioners Dwight Keene and Annie Keither. This is a docket number 24 CONS 3315 CPEN, and it's captioned in the matter of the failure of Utah Oil LLC operator to report activity that occurred during the 2023 calendar year in compliance with K.A.R. 823-409. We are going to begin with entries of appearance from council. I will start with commission staff.
Trustee Kimbrell, on behalf of commission staff and the public generally.
And for operator Utah Oil.
Keith Brock on behalf of operator Utah Oil.
Morning, Keith.
Good morning.
We will now move to notice of this proceeding. Does staff have a recommendation regarding notice of the hearing?
Yes. Notice of this hearing was contained in the presiding officer order setting this evidentiary hearing filed on September 12th, 2024. The order was properly served on all parties. Staff further notes that all parties are in attendance today. Based on these facts, staff recommends the commission find that notice is proper and that the commission has jurisdiction to hear this matter at this place and time.
All right. Are there any objections to notice? Hearing none, and based on staff's recommendation, I will find that notice is proper and the commission has jurisdiction over this proceeding at this time and place. Now, just a few preliminary matters, and then I'll discuss the procedure for the hearing. Before I ask if the parties have any preliminary matters, I'm just going to run through some of our standard reminders. First, because we're conducting this over Zoom, we know things can go wrong. If any party encounters a technical issue, please just ask to go off the record. We'll go into recess and resolve that issue before going back on the record. Second, witnesses are asked to keep their microphones off or muted when they're not scheduled to talk. If everyone would mute their cell phones, phones in their offices, and other electronic devices, that would be appreciated. Third, so the parties are aware, if the commission needs to consult among ourselves for something like an evidentiary ruling, we'll go off the record and the commission will enter into what's called the Zoom breakout room to discuss that, and then we'll return and go back on the record to make our ruling. And last, please be very careful to identify exactly what you're referring to when you're discussing pre-filed testimony or exhibits. We all have copies of everything on hand, so we should be able to follow along if you identify what you're speaking about. So with those standard reminders in place, do the parties have any other preliminary matters they want to take up?
Staff doesn't.
I'm seeing shaking of heads.
Yeah.
Good. We will move to the procedure for the hearing. In regards to the procedure, the parties are typically allowed to make opening statements. After opening statements, we'll have the examination of the witnesses. After the direct examination of each witness, there will be an opportunity for cross-examination, commission questions, and then redirect. Any further examination would just be at the discretion of the commission. Following the witness examination, we will allow closing statements and potentially arrange for the filing of post-hearing briefs if the parties believe it necessary, and then we'll conclude the hearing. So we will now move to opening statements. I don't believe that we have established any particular time limits, so we'll as long as we keep it reasonable, we'll just move forward without any limits. And I believe we will start with Mr. Kimbrell for commission staff.
Thank you, and I will keep it reasonable. Commissioners, the facts in this docket are not in dispute. The deadline in K.A.R. 82349 for operators to submit annual fluid injection reports, known as U3Cs, is March 1st. Utah Oil did not submit its U3Cs by March 1st. On March 28th, staff mailed a notice of violation letter to Utah Oil, giving a deadline of April 11th to submit its U3Cs or face a $100 per well administrative penalty. Utah Oil uploaded an Excel file to Kohler with its U3C data on April 1st, but due to a failure to hit the final submit button, did not submit its U3Cs on that date. Instead, Utah Oil submitted its U3Cs on May 1st, after the April 11th deadline in the letter. The commission issued a penalty order the next day. These facts are not in dispute. What is in dispute is what the commission should do with these facts. Staff believes that the commission should follow the plain language of K.A.R. 823-409. Utah Oil did not submit its U3Cs before the deadline in the regulation. Utah Oil did not submit its U3Cs before the deadline in the NOV letter. Therefore, Utah Oil should pay a penalty of $100 for each untimely U3C. Utah Oil, however, will likely argue that the commission should cut it a break. It'll point out that the failure to timely submit the U3Cs was a simple mistake. And that may very well be the case, but nowhere in 82.349 does it say U3Cs must be submitted timely unless it's a mistake, then it's okay. No, a violation of 82.349 that results from a mistake is still a violation of 82.349. In fact, a prudent operator should do everything in his power to minimize the possibility of making mistakes. Utah Oil could have uploaded its U3C data on January 1st, or January 2nd, or January 3rd, etc., etc. Instead, it waited to upload its U3C data until April 1st, a month after the deadline in 82.349. The failure to hit the submit button on April 1st may have been a mistake, but it was an avoidable mistake. More importantly, if the commission rescinds or reduces the penalty amount in this docket because Utah Oil made a mistake, the commission will be sending a message to every other operator in the state that as long as they claim a violation was a mistake, the commission will reduce their penalty amount. I think that would be an unfortunate message and one that would inevitably lead to many more hearings in front of the commission. Now, Utah Oil may also argue that it submitted the U3Cs before the commission issued the penalty order. Therefore, Utah Oil was in compliance before the penalty came out. To put it simply doesn't matter when the penalty order came out. Utah Oil missed the March 1st deadline in the regulation and missed the April 11th deadline in the NOV letter. The timing of the penalty order is completely irrelevant. Utah Oil may also talk wistfully about the good old days when staff was supposedly nicer to operators. I don't know about the good old days, but if staff ever treated certain operators more favorably than other operators, it was improper then, and it's improper now. Finally, Utah Oil may argue that it's a quote-unquote good operator and shouldn't be treated the same way as a bad operator. The problem with that argument is that whether an operator is good or bad isn't a regulatory question, it's a theological question, and it is certainly not a question the commission should consider when applying its regulations. The commission should stick firmly to applying its regulations as they are written uniformly and consistently to every operator in the state of Kansas. And ultimately, that is the crux of this entire docket. It's not about the facts, which aren't in dispute. It's about Utah Oil wanting the commission to treat it differently, to treat it better than it treats every other operator in Kansas. Staff strongly believes that would be a mistake. The very legitimacy of the commission rests on treating all operators in the state equally. For that reason, staff believes the commission should affirm the penalty order in this docket. Thank you.
Thank you, Mr. Kimbrell. Mr. Brock.
Thank you, Mr. Chairman. This is one of those dockets. I think it would be easier to show the commission some things. So if it's okay, I would like to share my screen. I've got a very short PowerPoint and then a demonstration as part of my opening statement.
Yeah, please go ahead. I assume you have the ability to share screen. If not, we'll get it to you. We can see your presentation.
Okay, perfect. So what this case is about is essentially the Utah Oil committed a user error in navigating the K.A.R system. The staff testimony is that there are 5 separate steps to submit this form. Utah Oil completed 4 of those 5 steps, believed that its form had been fully submitted, and then because they failed to click one final button, they've been penalized for 40 separate violations at $4,000 apiece. That will also trigger financial assurance obligations of basically $5,400 over the next 3 years. This case is unique in that the commission is not going to be asked to decide whether Utah Oil is simply claiming that they made a mistake. The commission's records clearly show that that was what occurred, and staff's testimony confirms that that's what occurred. And as we walk through this, I'll show you how you can confirm that. So I just want to point out that this is not a situation where it's one person's word against another. Did it move the K.A.R screen in front of my screen share? Okay, thank you.
Yes.
So this is the home screen on K.A.R, and I would just like to walk the commission through what occurred so that you can have a visual, you can visualize what happened. So this is how the K.A.R system opens. Utah would have then went to KCC forms. They would have went down to annual injection or annual report file upload because they have 40 different wells. That would have opened this screen right here. What Utah would have then done is they would have clicked this button, which downloads an Excel file. And this is what the Excel file looks like. It has all 40 of the wells. Utah would have then been required to complete these columns, listing what was injected, the pressures, the volumes, and then listing it out by month for the entire year, all of this data. Once Utah did that, had completed all of those fields, they would have came back and needed to upload the file right here. They choose upload file. We just have a dummy file. And so right here on today's date, or, oh, I'm sorry, I forgot to click upload. So we upload the file. And then right here, today's date at 8:41 a.m., you can see that this file is created. This is the step where Utah Oil got to and believed the form had been submitted. It was uploaded, it showed the date and time that it was created, and then it had these other fields that have submitted and returned. Utah believed that once the staff processed it and accepted it, it would appear as submitted, or if it was rejected for some reason due to an error, it would show as returned right here. And so once Utah completed that step, it simply stopped. It logged out of K.A.R, thought the form was filed, and moved on. The other important thing I would like for the commission to see, so the actual file that was created is right here. This is the one we're talking about. On 4/1 of 2024, you can see that this file was uploaded by Utah Oil. What they needed to do after that was to go over here and click detail on the left-hand side, which opens this screen. And as you can see, once this is in here, the commission can't see it, but I'm typing on these words. You cannot modify this form. Once it's created and it's uploaded, it cannot be changed. And so then once you've done that, you have to come up here to the top and click submit to the KCC. Out of this entire process, all of those fields that Utah submitted, this button right here is the only one that's what this violation is about. And the issue that we're taking is not that there wasn't a mistake. Utah acknowledges there was a mistake. But when we're looking at this with some common sense and some practicality, the fact that Utah didn't know that they got to this point and did not know they had to come over and click detail in order to find one last button and submit it, and that mistake led to 40 separate violations at $4,000 worth of penalties and $5,400 worth of financial assurance obligations, that is not reasonable. And I mean, honestly, the reason that we talked about before that this is not in dispute, these dates, we can see on K.A.R the date that those files are created. In addition, we filed with our pre-filed testimony the properties bar associated with this file that shows that it was not modified after this date. And so all the parties agree that the only inaction was basically the mistake that they didn't realize they had to click detail, open a separate screen to find one last button to submit it. And, you know, the fact that, you know, staff says that, you know, operators should avoid mistakes, that is true. But the reality is we all make them, staff included. And we don't feel that it's unreasonable to think that when someone does make a mistake, the commission staff should try to work with that person and look at the facts that they can determine and see that they legitimately try to comply with the rules. So as Mr. Kimbrell said, these facts in this case are undisputed. And that's why we're taking a little more time with our opening statement, because the facts are not going to be questioned. This report is an annual report. It's filed once a year. So even though staff would emphasize that different emails and things are sent, this particular operator, the person filing this report, they don't file these forms for other people. They do it one time a year. And so to insinuate that they should remember every keystroke from the year before, that's just not realistic. The other importance is that all 40 of these violations are for that one button. She didn't make this mistake 40 separate times. She made it one time. And instead, staff has tagged her with 40 separate penalties. The other fact that's not in dispute is that Utah Oil received this notice of violation. It required Utah Oil to take action by April 11, 2024. Utah Oil received that on Saturday. It would have been May 30th. They filed this, they made this filing, they uploaded this file to K.A.R the very next business day on Monday, April 1st. They didn't delay, they didn't wait. Their owner was calling the employee to make sure that they had made this filing. This operator has never received a penalty from the commission before. And so when they received this NOV, they took it seriously, just like you want every operator to take these NOVs seriously. Well, this operator did that, but they're receiving no, they're being treated as though they had just ignored it in their entirety. If Utah Oil had blown this off and not done this at all, they would receive the exact same penalty that staff is trying to impose on them right now. The other things that's not in dispute is that Utah legitimately believed it had filed this report. It didn't realize that there was one last button to click when you navigated to another screen. You know, and I would argue that for someone to intuitively know that they should click a detail button in order to find a different screen to click submit, that's not intuitive in terms of how the system works. That mistake is, it's easy to identify with, in my opinion. The second is that the staff in Utah all agree that this form had no errors, that there were no injection violations, that Utah fully complied with all of its permits, did not inject excess water, did not inject above permitted pressures, that form fully complied with the commission's regulations when it was submitted. The only failure was the one button click. The other thing that's undisputed is that form cannot be modified after April 1st. So that KCC staff can look at K.A.R and verify that it was in fact submitted, uploaded and created into that system that I just showed the commission, and that Utah had no way of going in later and making changes. So it was fully complete, fully submitted. And then the last one is that this one button stroke gave rise to 40 separate violations. So what are we asking for the commission? We don't believe that the position that staff's taking in this docket is reasonable. And so we've asked for this hearing to put the issue in front of the commissions themselves so that you can decide what policy you want to set. For years, the commission's goal has been to achieve compliance, not enforcement. They wanted operators to take the regulations seriously. They wanted them to take steps to avoid mistakes, but they did not take on a posture of being inflexible and penalizing someone just because they could. This policy has changed. In the enforcement activities, staff doesn't settle any dockets anymore. They don't offer any relief anymore. This is a drastic policy shift from the past. And so we're here to ask the commission if that policy shift is one that's endorsed by the commission or if it's not. The second point is, does the commission want its staff to work with operators? in the past, I have heard this commission and the commissioners ask questions to operators. Did you contact staff? They're generally very easy to work with. Did you contact staff? They want you to comply. That tells me that the commissioners themselves might want a policy that the staff would work with operators as opposed to just an inflexible bureaucracy that does not take into account the specific facts of the docket. And so that's what we're asking the commission. Is that what you as the commissioner still want from your staff, or do you want this inflexible approach? And the last point is, does the commission wish to set penalties that are in line with the violation? And I'm not suggesting that the commission should set each penalty uniquely, but I am suggesting that there are outlier situations. The commission has recently issued very large penalties against certain operators because they felt that the violations were overly egregious. In this case, you have penalties being issued that are overly harsh based upon the violation that's committed. If the commission wishes to exercise discretion to penalize more harshly than its regulations provide operators that have committed more egregious violations, it should use that same discretion to provide some relief when the evidence clearly shows that the operator did everything in its power to try to comply, committed an honest mistake, and is now receiving a very harsh penalty for what amounts to computer user error. So we're just asking to put these issues in front of the commission and let you guys decide what policy you would like going forward. So I thank you for the time. I thank you for indulging in that presentation and demonstration.
All right. Thank you, Mr. Brock. With that, we will move to the examination of witnesses, and we will start with staff. So, Mr. Kimbrell, you may call your first witness.
Thank you. Staff calls Ryan Hoffman.
All right. Good morning, Mr. Hoffman.
Good morning.
We do not have a court reporter, so I am going to swear you in. If you'd please raise your right hand. Do you swear or affirm that the testimony you will give today is the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. Go ahead, Mr. Kimbrell.
Thank you. Could you please state your full name for the record?
Ryan A. Hoffman.
Are you the same Ryan Hoffman who caused to be filed in this docket direct testimony consisting of 6 pages and 1 exhibit, and rebuttal testimony consisting of 6 pages?
Yes.
Do you swear that the answers contained in your pre-filed testimonies were and are true to the best of your knowledge?
Yes.
At this time, I would move for the admission of Ryan Hoffman's pre-filed direct testimony and attached exhibit and pre-filed rebuttal testimony to the formal record.
I have one objection, Commissioner,
Okay.
or Mr. Chairman. So my objection would be to just a couple sentences. It starts, it says in the rebuttal testimony that was filed on August 23rd, and it starts at the bottom of page 2 with the sentence stating my understanding. And then it goes to page 3 and ends with line 3.
I'm sorry, it starts at page 2, line what on page 2?
It's line 23, but it's really that first complete sentence starting on line 23. I apologize.
I've got you. My understanding is that banks.
Correct. Yeah.
Okay. Yep.
So the objection is really twofold. I understand the commission's evidentiary requirements are lax, but in this particular case, he's trying to give opinion testimony to an area that's outside the scope of his expertise. He is able to give opinion testimony on a lot of issues based on his background, but not based on private lending arrangements and the costs. In addition, my understanding indicates that it's clear hearsay. And so we object to that simply because we would have to conduct some cross-examination to flesh that out. And we haven't had the opportunity to get an expert on that issue as well.
Mr. Kimbrell?
Under CAPA, the commission can consider hearsay, and I would also point out that financial assurance is a part of what the commission requires operators to pay, and therefore Mr. Hoffman is clearly within his expertise in determining what kind of financial assurance operators would need.
Yeah, I'm going to overrule the objection. Mr. Brock, you can cross-examine as necessary. With that, are there any other objections to the admission of the reference testimonies? Hearing none, they will be admitted.
Thank you. I attended the witness for cross-examination.
All right. Thank you, Mr. Kimbrell. Mr. Brock, the witness is yours.
Thank you. Good morning, Mr. Hoffman.
Good morning, Mr. Brock. Feels weird calling you that.
I felt weird calling you Mr. Hoffman too. Would you agree that staff has verified that that the UC3 that Utah uploaded on April 1, that it was done on April 1?
Yes.
And do you agree that there are no known errors in Utah Oil's U3C filing that was updated on April 1?
Yes.
Would you also agree that staff has verified, or either manually or through the automated process of K.A.R, that all of the reported injection volumes and pressures reported by Utah are in line with its permits as issued by the KCC?
That I can't say for sure, Keith. I don't know that they went through them yet, but so I can't say yes or no on that one.
Would K.A.R automatically reject or automatically flag an error?
No, because yeah.
Okay. Do you know which of your staff would have reviewed them if someone did?
And see, the reason I don't know is because it depends on when they're submitted. There's a process after all the U3Cs are submitted. We wait till after the violations are issued to go through all of the U3Cs at once. Our U3C or UIC staff and our legal staff have a program that they run over the numbers that were injected to then flag them. And that's occurred. I just don't know that these came in during that time. That's why I can't say with absolute certainty.
I was just, is it possible that one of the other two witnesses might know the answer to that? That's all you don't know?
I don't think so.
Okay. Would you agree that if Utah Oil had clicked the final submit button on April 1st, 2024, that staff would not have recommended any penalties at all?
I think that's one way of saying it, yes. But I think
Thank you.
they could have avoided penalties as well by going back and viewing it when they got the NOV.
But just to clarify, you agree that had they clicked that button on April 1st, there would not have been any penalties?
Correct, if they would have submitted the forms.
Thank you. Concerning the cost of financial assurance, when we're talking about bonds and letters of credit, have you personally borrowed money, taken out bonds, letters of credit, loans?
Loans, but not bonds or letters of credit.
For a home, for example?
Yes. Home, vehicles, those kinds of things.
So when you borrowed the money for your home, was there an origination fee, a loan fee associated with that?
Yes.
And so would that be the 1 to 1.5% that you're talking about here?
No, I do want to be very clear that I get up to speed on financial assurance documents as much as I could in preparation for this hearing, and we reviewed documentation from FLH Bank out of Topeka and looked at theirs, and that was the source.
So let's just walk through the home, because it's a good example of how financial institutions work. In order to borrow the money on your home, did you have to do an appraisal to determine the value of the collateral?
Yes.
And was that a cost that you would have had to pay in addition to just the origination fee for the loan?
Yes.
And did you also have to purchase title insurance for the lender in order to demonstrate valid title to the collateral that you pledged for the bank?
I'm going to object at this point. This isn't related to letters of credit or bonds. I think we're way off base here.
This is absolutely related to the cost of a bond and a letter of credit is a loan, And whether you borrow it in this context or another, it has to be you have to pledge security. And by
But
banking
you're talking about
regulations,
house.
and,
Sorry.
and by banking regulations, when you pledge security for a loan, you have to go through certain processes to value the collateral, to determine the title to the collateral, and those are all costs of borrowing the money. This is why I objected to the testimony about the cost, because he's talking about the origination fees and none of the other.
So Mr. Brock, I'll be honest. I don't know whether the the home context is the same as financial assurance in the oil and gas context. I'll let you go ahead and ask some questions. You know, if you can make that connection, that's fine. It might be easier for me if you would ask it in the oil and gas context, just because it sounds like that's what Mr. Hoffman did his research on. But I'll go ahead and give you some time.
I'll ask the question, see if he knows. So in the context of borrowing money against an oil and gas asset, do you know how that oil and gas asset would be valued by a bank?
I do not. I don't have any oil and gas assets to take a loan against.
Have you reviewed reserve reports or anything that as part of your practice at the commission?
I've looked at them, yeah.
Would you think that that's the way that an oil and gas asset would be valued for collateral purposes?
I would imagine that would be included, but I think you would also take into account maybe the equipment that's available on the lease.
And I guess maybe I'll just ask the question directly and see if you can answer it. My point is that when you have to establish value and you have to establish collateral for something that secures a loan, wouldn't you agree that that can be substantially more expensive than simply the origination fee for the loan?
Yes.
And based on that, would you agree that the testimony that the financial assurance, the bond, and the letter of credit only costing $100 likely does not include the cost of valuing that collateral and ensuring its title before it can be
I'm going to
pledged?
object. I don't believe Mr. Hoffman testified that it only costs $100.
So it costs a few $100s. It's on the top of
And you said
page
$800. Yeah. You didn't specify
top
how
of
much
page
it would
3.
cost.
Go ahead and re-ask your question, and I'll let the witness answer.
So I'm going to rephrase the question just to make it a little easier. So at the top of page 3 of your pre-filed rebuttal testimony, you say, thus a letter of credit for $30,000 would likely cost operator only a few $100s. And so my question is simply, in order for an operator to borrow that money, wouldn't it also be required for them to incur the cost to value that collateral and also verify title to that collateral?
Yes. And that's something that I didn't consider, Keith.
And so then would you agree that the cost of obtaining that then is probably greater than a few $100s?
Potentially, yes.
Okay. Thank you. That's all that I was trying to get at. I have no further questions. Thank you very much.
All right, thank you. Well, I think we are ready for commissioner questions for Mr. Hoffman. Let's begin. Commissioner Keen, do you have any questions?
I have a couple, yes.
Okay, go ahead.
Yes. Good morning, Ryan.
Morning.
A couple of questions for me. I appreciate your indulgence. To what extent are Conservation Division enforcement and compliance efforts dependent upon the voluntary operator compliance or self-reporting? And kind of elaborate a bit on that, if you would.
Sure. I would say they are highly reliant upon operator self-reporting. There are certain forms within Kohler that do verifications on the data that's submitted to make sure that they're in compliance with the regs. But for the most part, the information that is submitted to us, we are heavily reliant upon the operator. I mean, there are things we can verify with cement tickets, how much cement was used, things like that. But for the most part, it's what the operator tells us.
As an extension of that, some of these questions I may ask you my questions are very numerous, but they may be a bit leading. So if you can work your way around that, I'm just trying to kind of cut to the chase here a little bit. As maybe an extension of what you just said, is not there some implication that, or inference certainly, that good faith efforts by operators are really significant and important in the administration and compliance of commission statutes and regs?
I'm not sure I follow your question. What do you mean by good faith? And
I'm going to let you define what I mean by good faith. I mean that there is. Well, I would define it generally as a genuine effort to attempt to comply with the underlying black letter of the regs, as well as the spirit of the regs.
sure, and I think for the most part, the majority of operators do make those good faith attempts to comply with the rules and regs.
Okay. Let's kind of cut to the chase here with respect to the matter before us here. In the administration and enforcement of the rule, which of course is 82.3.409 here, the rule that sets out the requirements for the annual filing of the U3C form. How would you distinguish between circumstances that would be analogous to those in the matter before us, where in effect, but for one step, there was an effort to comply, versus cases where there is either total operator indifference or no efforts to comply?
I'm sorry, what was your question exactly?
The question is, how would you distinguish between circumstances where there is an effort to comply, in this case, but for one step, versus cases where there is absolutely an indifference to comply or no effort to comply?
I would say that the difference in how I would differentiate them is those would be situations where there's an indifference or an attitude of unwillingness to comply, where we would ask, or the commission on its own motion would seek harsher penalties than what's allowed in the regulation. Because they are more egregious.
Okay. But let's say there really is no interaction between the staff and the operator. There just is a failure to comply. The result would be basically the same as it was in this particular instance in terms of the recommendation and the penalty order, would it not?
Correct. And in this case, I think there was an opportunity for communication when we sent the letter. And that's generally why I know it was a theme early on about the attitude of compliance and enforcement. What's the difference there? And we sent reminders, we sent a notice of violation, and a phone call to us could have probably helped a lot.
Okay. Going back to some of the observations that Mr. Brock made in his opening statement, I would appreciate your take on, and I'm going to paraphrase you, Keith, hopefully correctly. I think there was a statement made that the operator is concerned that under the circumstances, the penalties may be overly harsh, and that they should be more in line with the nature of the violation that is committed. He offered a number of reasons why I think he felt that there were mitigating factors here. Did you find any of those to be compelling?
No.
No further questions. Thank you.
Thank you. Commissioner Keither, do you have any questions?
Yes. Good morning, Ryan.
Good morning.
I just wanted to make sure I'm very clear. Do our operators have to file this report annually, correct?
Every operator who has one of our 16,000 plus
Right.
injection wells has to file that.
Right,
Yes.
right. Do they get training on Kohler?
No, there is, I believe Ms. Clute lays out in her testimony the steps that are on Kohler. And I think our staff I don't think there would be any dispute that if somebody is having trouble with the form, they can call and ask. And I would note that the upload process was something that was developed with the help of operators. We worked that through industry and had them help us develop the process.
And again, this report has to be done annually.
Correct. Yeah, on March 1st every year for prior year's injection.
Right. Okay, great. That's where I'm coming from. Thank you. That's all.
All right. I've got a couple questions, Ryan, and I don't know if you're the best witness for these, but you're going to get them because you're the first witness.
As far as I'm concerned, I'm not the best witness ever. This is my first time doing this, though.
This is well, every time somebody's the first witness, they get all the questions. So you've got your counsel to thank for that, I think. Just foundational questions to make sure I understand the fact pattern right. It's been sort of alluded to that there would be compliance if not for clicking one button. But I guess as I was reading the testimony, my understanding was even if that process had happened correctly, I mean, I don't know whether staff would have recommended a penalty or not, but the operator would not have been compliant, correct? I mean, even at the time they were uploading, they were late, correct?
They were late. Generally speaking, though, in an effort for compliance, to achieve compliance, that's why we send the notice of violation letters. And that the deadline in that letter was the April 11th. So if they would have hit submit on April 1, when we reviewed who had and had not submitted them after April 11th, they would not have gotten a penalty.
I guess I appreciate the significance of the NOV letter, but just to be even more foundational, I mean, are there operators that that submit early, in January?
Yeah, Denise can tell you the exact date, but I think it's January 1 that it opens up that they can start submitting that form. I don't think many people are that eager, but generally speaking, it's like any deadline. There's usually that lead up to the deadline, and then right before March 1st, I think life gets pretty hectic for our UIC staff.
Well, that was going to be my next question. I mean, are there quite a few that file before March 1st?
Yes, the majority come right then, at the week before.
So again, I understand the significance of your NOV letter, but if I understand your testimony correctly, the vast majority of operators don't. It's not standard practice for everybody just to wait to get their NOV letter and then make their filing. Would that be correct?
Yeah, correct. I would say starting after we required this form to be filed electronically, we started tracking, the compliance with it because it was much easier than counting paper forms. And I think typically we'll send anywhere from 100 to 200 notice of violation letters.
All right, I think that's all I had. I just wanted the context of how this timeline plays out and what standard practice is for folks. So I think you've gotten me there. With that, if there are no further commissioner questions, I'll turn to Mr. Kimbrell. Do you have any redirect? Oh, did I see Commissioner Keene? Did you raise your hand or?
You did, and I don't want to dwell on this too much, but let's go back to the NOV. Ryan, what's the purpose of the NOV?
It's to try and get operators to comply with the regulation without formal enforcement.
Okay. It's a notice. Literally a notice of the fact that there is an allegation that a violation has taken place, and it really puts the onus, does it not, of the back on the operator to take action in response to that to avoid penalties.
Correct.
Right. So in effect, it's sort of my phraseology, it's a second chance letter, is it not? I mean, it says you have a violation. We believe there's a violation. We're asking you to respond. If you respond and if you agree that there was a violation and you correct it, everything's copacetic. Is that not pretty much the way it operates?
I would say in this case, because we send reminders in January and a reminder in February, that this is really a third option, a third opportunity to avoid being penalized.
Okay. Thank you for your indulgence, Ryan. And Chair Prince, that's the extent of my question.
Mr. Kimbrell, redirect.
Sure, just quickly, Mr. Hoffman, I think you testified that Kohler doesn't flag overages or overpressurization of U3Cs. Can you explain why that is?
Yeah, it was at the time it was designed. We determined that if people were violating the terms of their permits, and we would rather they report to us that they were violating the terms of their permits than to let them know before they submitted their form that they were going to tell us they were in violation.
So it's possible when Utah Oil uploaded that Excel file on April 1st that there were overages or overpressurization. They just weren't flagged. Is that correct?
Correct.
Okay. I believe Commissioner Keen mentioned operators undertaking a genuine effort to comply. If an operator does do a genuine effort to comply, but they still violate a regulation, would staff recommend a penalty?
It's, to me, the genuine effort's the same as a mistake or any type of mechanical issue that you could have at a well. You can do your best and something wrong can still happen.
And I believe Mr. Brock mentioned raising penalty amounts. Can you explain when the penalty amount might be greater than what is in the black letter law of the regulation?
Sure. In this case, if Utah would have called us up and said, we're not filing these forms, you can't do anything to us, and then turns out that maybe they had more wells that they were injecting into without authority, that kind of thing, there would have to be something egregious that is above and beyond not filing the form.
And to your knowledge, does staff ever recommend penalty amounts below the amount required in the regulation?
Not to my knowledge.
Okay, thank you. No further questions.
All right, we did cover some ground with the commissioners and on redirect. So Mr. Brock, if you have a burning need to ask a couple
I have a couple.
recross. Okay,
I have a couple.
I'll
Thank you.
allow it.
Thank you. I just want to make sure there's not an inference that was made that isn't true. When you were asked the question about overages that were flagged on the UC3, are you contending that there were overages on this UC3?
No, I'm not. Just that Kohler would not have picked them up.
Okay. But to be clear, 100%, no one is claiming that they actually injected higher volumes or pressures than they were allowed. Okay, thank you. You had referred to the NOV earlier as an effort to achieve compliance. Is that correct?
Well, in conjunction with the reminder letters, yes.
And so for those 200 NOVs that you sent out, when the operators did comply with the NOV, would you consider that a successful then, that the NOV was successful, it got operators to comply?
Yes.
And if an operator filed something the very business day after they received it, would you believe that your efforts to get them to want to comply with the regulations were successful?
If they filed it, yes.
Okay. When you issue the penalties, is the purpose generally to provide an actual and substantial deterrent to violating commission regulations?
That's what the statute says.
And so if in this docket, I think the agreement is that this operator legitimately believed this form had been filed, and by virtue of the K.A.R system, had no reason to believe that it hadn't. Do you think that penalizing them would it change anything about what they did? Would it have avoided this mistake?
No.
Thank you. All right.
I have no further questions. I'm sorry.
Thank you, Mr. Brock. Any additional commissioner questions prompted by that or redirect prompted by that? I will give you one final shot, Mr. Kimbrell, if you want redirect.
Oh, no, I don't have any more questions. Thank you.
Okay. All right. Then I think we are done with you, Mr. Hoffman. We thank you for your testimony, and you may virtually step down.
Thank you.
Mr. Kimbrell, you may call your next witness.
Thank you. Staff calls Todd Bryant.
Good morning, Mr. Bryant. Please raise your right hand. do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth?
I do.
All right, Mr. Kimbrell?
Thank you. Could you please state your full name for the record?
Todd Bryant.
Are you the same Todd Bryant who caused to be filed in this docket direct testimony consisting of 5 pages?
Correct.
Do you swear that the answers contained in your pre-filed testimony were and are true to the best of your knowledge?
Yes.
At this time, I would move for the admission of Todd Bryant's pre-filed direct testimony to the formal record.
No objections.
Hearing no objections, I will grant the motion and admit the reference testimony.
Thank you. I tender the witness for cross-examination.
All right, thank you. Mr. Brock, the witness is yours.
I have no questions, Mr. Chairman.
All right. Are there any questions from the commissioners for Mr. Bryant? Commissioner Keen, I see you're off mute.
No questions for me. Thank you.
Okay, Commissioner Keither?
Yeah, no, thank you.
Well, I also have no questions. We've made this too easy for you, Mr. Bryant. With that, because there was no cross and no commissioner questions, I don't think there's any need for any redirect. So we do thank you for your time and getting up here to admit your testimony, but you may step down as well.
Thank you very much.
Mr. Kimbrell, you may call your next witness.
Thank you. Staff calls Denise Klug. Your video isn't working, Ms. Klug.
I'm trying to.
Oh, okay.
We'll give a moment to see if there we go. All right. Good morning, Ms. Klug. If you will
Good
please
morning.
raise your right hand. Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Kimbrell?
Thank you. Please state your full name for the record.
Denise Klug.
Are you the same Denise Klug who's caused to be filed in this docket direct testimony consisting of 6 pages and 2 exhibits and rebuttal testimony consisting of 3 pages?
I am.
Do you swear that the answers contained in your pre-filed testimonies were and are true to the best of your knowledge?
I do.
At this time, I move for the admission of Denise Klug's pre-filed direct testimony and attached exhibits and pre-filed rebuttal testimony to the formal record.
No objections.
Hearing no objections, we will admit the reference testimonies.
Thank you. I tender the witness for cross-examination.
Mr. Brock, any cross-examination for this witness?
No questions, Mr. Chairman.
Any commissioner questions?
Yes, please.
Okay, go ahead, Commissioner Keen.
Good morning, Denise.
Good morning, Commissioner.
Your job is a very diverse one. You do many different tasks. One of the important tasks certainly is the processing of these U3Cs, is it not? Overseeing the processing of the U3Cs, is that fair?
No, I support the K.A.R system, which is the tool used for 17 different forms. The U3Cs are submitted on K.A.R, but I don't get involved unless I get calls from an operator that's having difficulty with the website.
Very good. Good answer. Thank you. Thank you for correcting me and providing that granularity. That's helpful. How many U3Cs, Mr. Hobbin alluded to this a bit, but how many U3Cs are processed through K.A.R annually?
Generally around 16,000.
Okay. And what level of compliance do you ordinarily see? The reference has been made to 200 NOVs. Is that the level of compliance follow-up as a general rule?
I don't get involved in the NOV process usually. That's handled by the legal department. I did look at this year's volumes because of this hearing, kind of in preparation. And we track the U3Cs are counted by a U7 or U3C form being submitted on each well. And that's how we come to 16,000 forms being submitted. And by March 1st this year, we had right at 93% of the ones that have been submitted so far, close to 16,000.
Okay. In this instance, and for U3Cs generally, In your opinion, what is the significance of pushing the submit button?
Well, that sends it to the KCC.
Is there any other significance associated with that one particular function?
There are a couple. When you click the submit button, regardless of, there are two options for submitting U3C forms. You can submit one form per well, and on each of those, after you create the form, you click the submit button. When you click submit, you will be prompted to certify that the information is complete and accurate to the best of your knowledge. And then you click on the individual forms, you click a checkbox and click OK. On the file upload method, it allows operators, any operator, but it's mainly used by operators with many, many wells. Instead of having to submit an individual U3C form on each of their wells, as is required, they can use the opportunity to submit an Excel file, as Mr. Brock demonstrated, which lets you scroll to the right and complete all of the information for each well on a separate line of the Excel spreadsheet. And then you upload it into the system, and the system will do some validation. The submit button will not be available to you until you have completed any errors that would be disclosed on that initial upload screen. When you're ready to submit, and when the download template downloads just the wells that are in the system today, the directions indicate that if you have had any wells transferred to or you have transferred wells off of your license, or if you have plugged any of those wells, you would have to manually add those rows to that spreadsheet. They wouldn't be included in the downloaded template. So once it's uploaded, then the process is to click the detail screen and see the details for each of the wells that you will be creating a U3C form for when you submit it. And then when you click the button submit to KCC, you'll be prompted. There will be a warning that you have to respond to. I certify this information is correct and accurate to the best of my ability. And then when you click the submit button, that's when the individual forms actually get created, the U3C forms, one for each row in that spreadsheet. And then they are sent to the KCC, and most of them are automatically accepted, entered into the database, get imaged as, a document submitted on that well record, and then the reporting can be done from the database that's needed.
A great overview of the process. Thank you for the granularity of that. My final question is, I want to go back and kind of extract from that overview that you provided two, I think, potentially consequential matters that may have some bearing on the docket before us. So if I'm understanding you correctly, and if I'm wrong here, you want to embellish it, please do. That basically there's a couple of really, I think, major significant points that come about in anticipation of pushing that submit button or by doing that. One, as I understood, is that there is error notification. Is that right? If there's some errors or discrepancies in data, that it will call attention to that. Is that correct?
It's mainly validation that every required field that has been completed on that spreadsheet for each well has been completed. It's just validation that things that are required are there.
Okay, very good. Thank you. But it strikes me that another, and you've alluded to it a couple of times, actually, significant factor involved in submitting is the fact that before you get to that step, there's no requirement to either have an attestation or confirmation of the correctness of the information being submitted. But through the process of actually submitting, the very step leading to that submission, is a prerequisite, is it not, a requirement that you have to have an attestation as to the correctness and completeness of the information being provided?
Before the submit to KCC button will be enabled for you to be able to click on it, yes, you must.
Yes. It's an enabling step to be able to push the submit button. Is that not correct?
That is correct.
Okay. Well, I do have another question. As you indicate, a lot of our operators will file on individual wells. If their injection well count is high, they'll do it under Excel spreadsheets and other methods by which they can file in the aggregate. Isn't that correct? For all wells.
For oil wells,
all wells. No, not oil. Injection. All wells. All injection wells.
All injection well. This is the only form that allows the multiple forms to be created by one file upload. This is the only form in the K.A.R system that allows that because of the, it's required annually. Did I answer your question?
I didn't mean to interrupt you. I think we were talking over each other.
Yeah, I think Denise, you cut out briefly. I don't know, Commissioner Keen, did you get the full answer you needed?
Not really. It wasn't that clear. If you could repeat that again, Denise, please.
This is the only form of the 17 forms in K.A.R that provides the option to submit multiple forms through one Excel file upload.
Okay.
Was that the question?
That's close enough. Let me ask another question. Were you online during Mr. Brock's opening statement when he went through the various steps that were involved in the K.A.R process as it affects the U3C form?
Yes, sir.
Were those steps accurately portrayed?
They were. The step that was missed was step 5, which is the step that actually submits the forms to the U3C. We don't know the Excel file has been uploaded to individual operators' workspaces on K.A.R. We don't see them until they're submitted to the KCC.
So let me see if I understand that one correctly. Notwithstanding the fact, let me get my notes out here for a second. So notwithstanding the fact, I'm picturing in my mind's eye here the form that had the submit capability on it that was not, that was the final step that was not taken. I'm visualizing that form because that form actually did provide information about steps that have been taken by the operator prior to submission. So there is somewhat of an electronic trail, is there not, of actions the operator is taking in anticipation of submission.
Yes, but that is in the operator's workspace. When a user logs into K.A.R, based on their permissions and which licenses they have been granted permission to, they see the unsubmitted, the work in process forms that are in their queue. But those don't get sent to a KCC workflow queue. The U3C forms go into the UIC department's workflow queue once they are submitted to the KCC. It's each operator's workspace to design their forms, create them, get them ready to submit to the KCC, but they don't show up in the KCC's workflow to be processed until they are submitted to the KCC.
So if I'm understanding you correctly, prior to submission, you cannot, of your own volition, go out and determine what processes the operator has taken prior to submission.
What we can do sometimes, and this is where, in this instance, when I was asked, can we verify when the Excel file was uploaded? I was able to go to our test system, which gets refreshed with production data, and add myself as a user to the license, to the group for Utah Oil. And then select that group to look at the workspace records. The screen, the detail screen Mr. Brock was demonstrating, is only available to the operator that has permissions to this. As a system administrator in our test system, I can make myself a member of their group and see what's in their work queue. And you saw that it had previous submissions of file uploads. And you have to have the permission level. There's a permission level to create forms, and then also a permission level to submit forms. And the group administrator for each operator assigns those permissions, who has permissions to do that. And it's designed to be flexible, to be standardized in the forms that are submitted to the KCC, but also to be flexible enough for the different operators' business processes and workflows. Some operators that have 200 or 300 injection wells will submit multiple file uploads during the reporting period that generate a U3C for each of those wells. But it allows them to have control over when they submit it, when it's, if they want someone in the office to be responsible for uploading the form and doing the data entry, but then someone else has the responsibility to review those details and say, yes, submit this, I certify this is accurate and complete. It's designed to be flexible enough for the different operators' workflows.
Okay. Then the electronic history of the actions taken by the operator in anticipation of the ultimate submission of these U3Cs. How readily available would that be?
Well, in this instance, I
didn't finish my question. How readily available would that be to the legal department in anticipation of issuing enforcement orders or requests?
I mean, they would need to come to me as an administrator of the system to kind of go in through our test system, make sure it's refreshed with the latest information from production, and look up each one individually to see what's in their workspace. It's not readily available to us. Only the submitted forms are available to KCC staff.
I get you. No further questions. Thank you for your assistance, Denise.
You're welcome.
Commissioner Keither, do you have any questions for Ms. Klug?
I don't. Thank you. I'm learning a lot.
I also do not have any questions. Mr. Kimbrell, do you have any redirect?
No, I don't. Thanks.
Mr. Brock, there was some pretty extensive questioning there. Do you have the need for any? I know you didn't initially do cross, but we may have tread some new ground. I want to give you an opportunity.
I just have two questions, and I just want to make sure the record's clear with the two questions. It's really not what I'd consider substantive. Mrs. Klug, you testified that there are about 16,000 U3C forms submitted each year.
That's correct.
And isn't it correct that you're referring to one form for each injection well when you're referring?
I am.
Okay. And then later on, when Mr. Hoffman talked about notice of violations and there were 200 to 300, in that he's referring to a notice given to an individual operator. Would you agree with that?
I would.
So like for example, in this case, Utah had 40 wells, would be 40 separate or 40 U3C filings as you're counting them, but they received one NOV.
I believe that is
Who
Correct.
cares?
Um,
When they submit the forms, they will receive 40 individual emails acknowledging that the U3C for that individual well has been accepted.
Yeah, no, I understand. I just wanted to make sure the numbers were clear. So, because when you testified about the 16,000, it seemed to imply that you were saying out of 16,000 people, only 200 didn't comply. I was just trying to clarify that wasn't the case.
No, 16,000 wells.
Okay, thank you. The last question, you referred to a work in process form that the operator has in K.A.R. that when they upload the UC3, that it's a work in process form. Do you recall that?
It's their workspace. It's their own workspace. Yes.
And would you agree that once that's uploaded, they can't change it?
No, they can once they upload it, there is a high level validation that on that first screen, it will point out how many errors there are, how many warnings there are, how many just different. There were 3 different columns. So if one or more of those rows had been missing injection numbers for a certain month of the year, that would show up as an error. You can't correct the error there. Your step then is to go back to the Excel file that is stored to your PC, make the correction there, re-upload it, and it will be revalidated there. That is,
And that if they did that, it would show as a new upload date, correct?
that's correct.
So I just wanted to make it clear that once Utah uploaded the file on April the 1st, there was no way for them to add to it, or the filing was complete when it was uploaded.
The Excel spreadsheet that they completed was uploaded. Yes.
Okay. Yeah, we're on the same page. That's all that I had. Thank you.
All right, did that prompt any additional commissioner questions or redirect? I'm seeing shaking of heads, thankfully. All right, I appreciate all of your indulgence of our questions, Ms. Klug. We thank you for your testimony. You may virtually step down. All right, looks like we have made our way through all of staff's witnesses. We've been going a little over an hour, but we do still have 2 more witnesses left and closing statements. Let's just take is everybody okay with a 5-minute break? Just to give you time to refill your cup of coffee, and maybe we come back. Well, we're at 9:42. Let's plan to come back at 9:50. So we are now off the record, taking a short recess until 9:50. All right, my clock shows 9:50. Looks like we've got Mr. Kimbrell. We've got Mr. Brock. All right, at this time we've made it through all of staff's witnesses. We are now ready for operators' witnesses. Mr. Brock, you may call your first witness.
Thank you, Mr. Chairman. We'd call D. Rail.
Good morning, Ms. Rail. If I can
morning.
have you please raise your right hand for me. Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, thank you. Mr. Brock?
Thank you, Mr. Chairman. Can you please state your name and address for the record?
D Rail 35510 West 363rd Street, Osawatomie, Kansas 66064.
And are you the same D. Rail that caused to be filed pre-filed testimony in this docket consisting of 6 pages and 1 exhibit?
Yes, sir.
And do you have any changes or corrections to your testimony?
No, sir.
If I asked you the same questions today now that you're under oath as are contained in your pre-filed testimony, would your answers be the same?
Yes, sir.
I'd move for the admission of the pre-filed testimony of D. Rail consisting of 6 pages and 1 exhibit.
No objection.
Hearing no objection, we will admit the reference testimony.
Thank you. I tender the witness here, Mr. Chairman.
All right. Mr. Kimbrell, any cross-examination for this witness?
Yes, I do. Thank you. Ms. Rail, I believe in your testimony you indicated you work part-time for Utah Oil. Is that correct?
Yes, sir.
And what are your duties with Utah Oil?
Generally, I handle payroll and I do some reporting for them.
Okay. Do you fill out all the Kohler forms for Utah Oil?
No, I do not, sir.
Okay. Who else fills out Kohler forms for Utah Oil?
We have some consultants that help us, like Phil Frick and Drill Baby Drill.
Okay. Do you know how many years Utah Oil has been submitting its U3Cs through Kohler?
I do not know.
If I were to say 2016 through 2014, would you have any reason to doubt that those are the years that Utah Oil has been submitting Kohler, U3Cs and Kohler?
No, sir.
For each of the years that Utah Oil has been submitting its U3Cs to Kohler, who has submitted those U3Cs?
Probably myself.
Okay. And when you submitted the U3Cs in the past, did you upload an Excel file in Kohler like you did this year?
Yes. Well, most recently I've been doing the Excel file. Before that, I was doing each of them individually.
Okay. For how many years have you been doing the Excel file?
I don't recall, sir.
Okay. In the past, when you had uploaded the Excel file, did you ever fail to hit the final submit button before?
No, sir.
Okay. I believe you testified that you uploaded Utah Oil's injection well data to Kohler on April 1st, correct?
Yes, sir.
And then you successfully submitted the U3Cs on May 1st, right?
Yes.
Okay. I'd like to go to your testimony, so I will share my screen.
Okay.
Okay. Can you see your testimony? Oh, sorry. I haven't hit the share button yet. There we go. Can you see your testimony?
Yes.
Okay. I'm going to go down to page 2, line 5 of your testimony. And starting on line 5, I believe you testified that okay. So you testified that after you submitted the uploaded the U3 the Excel file on April 1st that you thought that the U3Cs were in the KC's hands for review approval. Is that correct?
That is correct.
Okay. At any point between April 1st and May 1st, did you check Kohler to make sure that the U3Cs had been successfully submitted?
No, sir.
To your knowledge, did Phil Frick or Drill Baby Drill check Kohler between April 1st and May 1st to see whether the U3Cs had been successfully submitted?
I have no idea what they did.
Okay. I'm going to go down to your exhibit in your testimony. So this is
Mr. Just real quick, I'm not trying to object, but when I was matching it up with my testimony, and I don't think we were on page 3. I was just wanting to, I just think we need to correct the page reference that Mr. Kimbrell was talking about.
okay. So I'm sorry, what page did I say?
I thought you said page 3, line 5. Maybe I misunderstood. I was just trying to.
Oh,
I'm not asking it to be changed. I'm just wanting you to.
mhm.
correct page
If I did say 3, I meant to say page 2.
2. Okay, I think that's all.
Okay. So moving down to your exhibit. So on your exhibit email, it's page 3. So it's PDF page 10. And is this an email that you sent on May 1st? I'll scroll up so you can see the date. Is this an email you sent on May 1st, Ms. Rail?
Yes.
And in the last sentence of this third paragraph, did you write, I have learned from this lesson and I follow up after my letters we received from the state going forward immediately. Did I read that correctly?
Yes.
So would it be accurate to say that the penalty order in this docket has acted to deter Utah Oil from committing similar violations in the future?
Absolutely.
Okay, thank you. I have no further questions at this time.
Oh, all right. Are there any commissioner questions for this witness? Commissioner Keen?
Yes, thank you. Good morning, Ms. Rail.
Good morning.
How familiar are you with KCC filings using K.A.R? I'm a little confused about that.
I've done them off and on for several years, but the U3Cs are really one of the only things that I do, and I do them annually. And then I renew my father's oil license. That is really all I use K.A.R for.
Okay. Other than that, if I understood it, you would farm out this to other entities or companies. Is that right?
Yes, sir.
They would provide all other compliance filings except for those 2 that you allude to.
Yes, sir.
Okay, let's focus now on the U3C processes and in your involvement once again, if I could. Going back to one of the questions that Mr. Kimbrell asked of you, was 2020 that you're in 2024, you're providing information that's germane to the wells with respect to 2023. Is that not correct?
Yes, sir.
And so had you used this Excel spreadsheet approach, this Excel file approach, to do the multiple well filings prior to the filing in 2024 for 2023?
Yes.
So this was not the 2024 filing for 2023 was not the first time that you had used the Excel approach.
I believe I used it the year previously also.
Okay. And then prior to that, if I understood your testimony, you were filing on these wells individually.
I believe so.
Okay. Okay. In your experience then in filing basically these 2 types of forms using K.A.R, including the U3C forms that are at issue here, Do you find using the K.A.R system to be complex or onerous?
It can be confusing at times. There's several times I've had to call for assistance.
Okay. When Utah Oil received the notice of violation that pertained to these U3C filings, were you made aware of that at the time the company received that notification?
Yes, I was notified immediately and began working to complete that spreadsheet so it could be submitted immediately.
Okay, I'm not checking the calendar here, but as I understand it, you subsequently submitted it on Monday, April 1st. Is that correct?
Mm-hmm. Yes.
Or at least you prepared it on the 1st, but for failing to submit, press the submit button, if you will, kind of cutting to the chase here, you believed you've done everything necessary to comply with the rule.
Yeah.
Look at your pre-file once again. All right, I believe that concludes all of my questions. Thank you very much, Ms. Brown.
Thank you.
All right, Commissioner Keither, any questions for Ms. Rail?
Just to reconfirm, good morning, Ms. Rail. Thank you for being here.
Morning.
You state that you've been responsible for filing the UC3 forms for Utah Oil. And you've uploaded, used both systems, individual and uploading the multiple. And you're saying, I'm just confused how you didn't understand that you had to do the submit button.
It's just something that's.
I'm sorry.
Sorry, excuse me. It's just something that is done annually. I just didn't remember from the year before that you have to select that detail button and go to a previous screen. When I uploaded the file, it showed below that the file was received, and I thought I was completed.
So it was a different response than the ones you've gotten before when you've hit the submit button. It just didn't, it looked different, didn't look the same. I mean, I'm confused, I guess.
I mean, I don't remember what the screen looked like.
Looks like, okay.
Sorry, I just don't recall.
Okay, thank you. That's all.
All right, thank you, Commissioner Keither. I actually have no questions for you, Ms. Rail. I thought your testimony was very comprehensive and explained your position, so I don't think I need any clarification at this time, but I do thank you for your testimony. With that, Mr. Brock, any redirect?
No, thank you, Mr. Chairman.
Okay. All right. If there is no need for a recross, then I think we'll move on. Ms. Rail, you may virtually step down. And Mr. Brock, you may call your next witness.
We would call Brad Leach. He's in the same room as Mrs. Rail is.
That's fine. We'll give him just a second to rearrange. And John, are you able to? Perfect. Perfect. Got the name changed. All right. Mr. Leach, if you are ready to go, I'm going to swear you in. If you would please raise your right hand. Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth?
I do.
All right. Thank you. Mr. Brock, you may proceed.
Thank you, Mr. Chairman.
And you can lower your hand.
You can put your hand down. You're good.
Okay.
Can you please state your name and address for the record?
My name is Brad Leach. I live at 2394 Utah Road, Rantoul, Kansas, 66079.
And are you the same Brad Leach that pre-filed testimony in this docket consisting of 5 pages and no exhibits?
I am.
And I think it's contained in your pre-filed testimony, but you're one of the owners of Utah Oil, correct?
That is correct.
And do you have any changes or corrections to your testimony?
No, I do not.
If I asked you the same questions contained in your pre-filed testimony today, now that you're under oath, would your answers be the same?
Yes, they would.
I would move for the admission of the pre-filed testimony of Brad Leach consisting of 5 pages, no exhibits.
No objection.
Hearing no objections, the reference testimony will be admitted.
I'll tender the witness, Mr. Chairman.
All right, thank you. Mr. Kimbrell, any cross-examination for this witness?
Yes, I do. Thank you. Mr. Leach, were you listening earlier in this hearing when Mr. Brock was questioning Director Hoffman?
Yes, I was.
Okay. And so there was some talk about the cost of a performance bond or a letter of credit. Oh, sorry, can you hear me?
You broke up a little bit, but yeah, I did hear about the performance bond or letter of credit. Yes.
Okay. Did you speak to a bank to determine how much they would charge you for such a bond or a letter of credit?
I did not.
Okay. So you are a member of Utah Oil, correct?
That is correct.
And how many other members are there?
One.
And who is that other member?
His name is Lawrence Spratt.
Thank you. So as a member of Utah Oil, in a typical month, how many times do you access Kohler?
0.
And what about Mr. Spratt? How often does he access Kohler?
He does not either. No.
Okay. So would it be fair to say that in April of 2024, none of the members of Utah Oil checked Kohler to see whether the U3C forms had been submitted?
That would be correct.
Okay. I'm going to go to your testimony real fast, so I'll share my screen. All right. Can you see your testimony, Mr. Leach?
Yes, I can.
Okay. I'm going to go down to page 3, line 3.
I'm going to have to get in my...
Is that large enough? I can enlarge it if you need.
I actually have a printed copy here in front of me.
Oh, okay.
Page 3, line 3.
Yes.
Okay.
So I believe it says U3C violations almost always involve operators who have failed to timely file the required form and then ignored one or more notice of violations before a penalty is issued. This is simply not what happened in this instance. Did I read that correctly?
Yes.
Utah Oil failed to timely submit its U3C forms, though, correct?
Yeah, they failed to submit, yes.
And Utah Oil received a notice of violation letter before a penalty was issued, correct?
That is correct.
And Utah Oil did not submit its U3Cs before the deadline in that NOV letter, correct?
That is correct.
So would it be fair to say that this is exactly what happened in this instance, that the U3C violations were not timely filed and a notice of violation letter was ignored? Is that correct?
Yes.
Okay. I have no further questions at this time. Thank you.
Thank you, Mr. Kimbrell. If you could, yeah, thank you. With that, we will move to commissioner questions. Commissioner Keene, I see you're off mute. Do you have questions?
Yes, I have a few. Thank you. Good morning, Mr. Leach.
Good morning, Commissioner Keene.
Tristan, could you put page 3 of Mr. Leach's pre-filed testimony? Could you do a screen share on that for me? All right. Thank you. Can you see that, Mr. Leach?
Page 3, yes, of my testimony.
Yes. I also want to focus on the paragraph beginning on line 3, but it goes all the way through line 7. And you can take a moment to read that if you wish. Tell me when you've done that.
I have done that.
All right, thank you. I noticed on line 5 that you allude to what you believe to be unique facts involved in this docket that if we were to rule in your favor in some way, you believe would not create some objectionable larger policy objective frustration here. What do you believe are the unique facts that are involved in this docket that the commission should pay particular attention to?
I believe that I believe that in talking with Dee that we both agreed that she had submitted the form. It was for lack of clicking that one button. It was never intended to ignore the policies of the KCC or the regulations. And we do take great pride in that we try to cooperate with the KCC, and we work with the KCC on an ongoing basis.
All right.
Does that answer? Does that answer the question?
I want you to be as expansive or brief as you wish to be. I'm just trying to discern from your opinion, based upon your opinion, what the unique facts are that you believe would differentiate this violation from other violations of the U3C reg.
It was not the upload or the submit button was the reason we're here today. It was a mistake. I will totally agree with that. It wasn't an intentional violation of KCC policies. I can say that, you know, I have full faith in my daughter. I don't have her doing these things because she's my daughter. I have her doing these things because she's extremely competent. I take great pride in the fact that she is my daughter, but if she wasn't competent in doing work for our company, I would not have her doing it.
All right, thank you. If you would, Tristan, screw her down. All right. I'm not going to have any screen share on this, Mr. Leach, but I'm looking now on page 5 of your pre-filed testimony. If you could turn. Okay. In several, there's a couple of different places on page 5 of that pre-filed testimony when you make reference to what you're really requesting, I think, of the commission in these proceedings by way of my words, a modification of the penalty. Could you address that subject for us a bit? What your concern is here? What is it that you're really asking of the commission with respect to the action that we should take at this point?
To be real honest, Mr. Keene, it's not the financial part is important to us also, but the fact that we're going to receive 40 violations for one simple mistake, it wasn't intentional. Just from my personal point of view, it makes us look like we're a bad operator, and I do not feel that we've ever tried to be a bad we've always made every effort to be a good operator. And since the upload of the file can be documented, there isn't any instance where someone would do that, believe they had it done right, and if they knew to click that submit button, that they would not have went ahead to that next step. I was thoroughly convinced that she had submitted the file. She was thoroughly convinced. We thought we were totally good at that point. And I regret that I didn't follow through, but I was so sure that everything was done correctly that I didn't follow through, and that was a mistake on my part.
Okay. I appreciate that background. It's helpful. So basically, I take it from page 5 here that you're asking for some kind of reduction in the penalty. Is that what you're asking for?
Yes.
Okay. My final question is this. It's an overview question. Tell me a little bit about Utah Oil. How many wells in total, production, injection, do you operate? Ballpark.
Probably about 120 producer wells and 40, at this point, 42 injection wells.
All in Kansas?
And yes, there will be 46. The permit on the other 4 is still, yeah, they are all in Kansas, and there will be 46 when that permit is approved.
Okay. What's your, are you primarily an oil production company?
No, we provide oil field services as a contractor. We've done extensive plugging on the federal project for the state. And basically that's what we do. We operate our own production, but we also, in the past, we've drilled wells for other companies, and not so much now, but my experience in the oil field goes back to 1980.
Okay. And you pull wells as well, you're telling me, and plug?
Yes. Yes, we have the ability to do pretty much everything except the wire line and the fracking aspect of the whole well process from start to finish.
Okay. And how many counties do you operate in, basically?
Predominantly just in our production, it would be Miami and Franklin County.
Okay. Okay. Any prior violations or prior notices of violation or any kind of enforcement action involving Utah Oil in the past?
I believe I have received notices, but never any violations.
Okay. Thank you very much for your testimony, Mr. Leach. I have no further questions.
Thank you, Commissioner King.
Commissioner Keither, do you have any questions of this witness?
No, I don't. Thank you.
And I actually also do not have any questions for you, Mr. Leach, but I appreciate your testimony. Mr. Brock, any redirect?
Just a couple, Mr. Chairman.
Go ahead.
Earlier during the cross-examination, you were asked about whether or not you ignored the NOV that was issued. Do you recall those questions?
Yes.
Do you recall when you received it?
The NOV would be the one at the end of March. Is that correct?
Correct. The letter telling you that the UC3 needed to be
that would have been on Saturday, I believe, the Saturday before the end of the month. I can't recall the date, but
and so when you receive, I'm sorry, I didn't mean to cut you off.
No, whatever the date was, the Saturday right before the end of March.
And when
If
you
that makes
received it, did you do something about it?
Yes, I did. Immediately when I saw the letter, I called Dee and told her about the violation, or the letter that I'd received for the violation.
And was that also on that same Saturday?
Yes, it was immediately.
And then the form was created and uploaded when, on what date?
The following Monday on April 1st, and that was since the end of the month was not on a business day. I actually told her I didn't see why it wouldn't be okay to do it on the first business day after the end of the month.
And so just to be clear, you didn't ignore the NOV, you took action on the same day that you received it.
Oh, absolutely not.
Okay. Earlier there was some questions about the unique facts in this docket that would alleviate any concern about setting policy for the future. Do you recall those questions?
Yes, I do.
And just to summarize, I think you said both of them, but just to summarize to make it clear, did you essentially say that one of those unique factors was that you actually submitted the form or uploaded the form onto K.A.R?
Yes.
And the second, I think you said at a later time, but is it that the KCC can unequivocally verify that it was completed and submitted on that date, that it's not your word against theirs, that everybody can tell with absolute certainty that's what happened?
The form was uploaded but not submitted on that date. It was completed. It was completed, but not submitted, and that was the error.
I guess I'm just pointing out this, you're not asserting a lost in the mail type of defense, where in this case, both the KCC and yourself can see the day when it was uploaded. Is that correct?
That is correct.
And that makes it unique in your mind?
I believe so.
Okay. The last question was about what you're requesting in this docket. So you've chosen to hire an attorney and to bring this issue before the commission. What bothers you the most about this docket that caused you to incur that expense and to do this?
The main reason is I don't want to have our company associated with 40 violations. I take great pride in that we've never had those type of things happen. I think I have a very good relationship with the conservation division of the KCC, and I just, regardless of what happens here today, I still want to continue that good relationship. So the money's secondary.
So it'd be your reputation and the way that you're seen. Is that accurate?
I believe your reputation is everything.
And would it also be true you probably spent more money on the hearing than you have than you would have on the penalty? Is that true?
That is correct. Yes.
Okay. And just to be clear, you're still expecting and willing to pay a penalty to the commission. Is that correct?
Whatever the commission decides, we will, that's what this is all about. Whatever the commission decides is good with me. I just want to point out why we don't think that the penalty. We think the penalty is far too much for just a simple mistake.
But you are willing to pay. I mean, you're expecting the commission will find that there's a violation and that you're going to pay a penalty. Is that fair to say?
I can't say what the commission might or might not do. I would hope that they would see the special circumstances in this particular case.
That's fair. I guess I'm just trying to get the point across. It's not about the money or an intent to avoid a some kind of monetary obligation. Is that be
No,
right?
that's not the like I said, it is a factor, but it's secondary to the penalty, the amount of penalties that we would receive.
The number of violations.
The number of violations.
And it's at the end of your testimony, but just to summarize, in order for your company to be spared of the financial assurance cost, the $5,400 over the next 3 years, the penalties would need to be reduced below 3 in number and below $3,000 total. Would you agree with that?
Yes.
No further questions.
All right. Any additional commissioner questions or recross necessary?
I had a couple of questions, Chair French.
Go ahead, Mr. Kimball.
Thank you. When you were being asked questions by Commissioner Keene, I believe you said that you thought that Ms. Rail had submitted the U3Cs on April 1st, but you expressed regret that you didn't follow through to make sure that she'd submitted them. Is that correct?
That is correct. I take
Okay.
full responsibility for, when you're in charge, you take responsibility for everybody's actions. And I take that very seriously, and I regret not following through on that. I was convinced, though, that it had been done.
Okay. And so that was actually my follow-up question. So as one of the 2 members of Utah Oil, do you believe it's your duty to follow through on stuff like this to make sure that Utah Oil stays in compliance?
Yes, I do.
Okay. Thank you. I have no further questions.
All right. Just checking if there's any further commissioner questions. Looks like no. All right. Very good. Mr. Leach, thank you so much for your testimony. You may step down.
Okay,
With
thank
that, thank you. We have come to the conclusion of all of our witnesses, and we are now ready for closing statements. I don't believe we established any time limits, so I'll again just ask that you all stay within a reasonable time frame. We have Mr. Brock first to make a closing statement if you're ready.
Yes, thank you, Mr. Chairman. So at the outset, I think it's been made clear in this docket, but I want the commission to know that in this docket, you can issue the penalty. No one is arguing that legally you don't have that ability. No one is arguing that there was not technically a violation of the black letter law of these regulations. The argument is that this operator in good faith took steps to do what they believe complied with it. With these forms that are required to be filed, they have to collect data every month. And this operator did that daily. They collected it through the entire year. And then Mrs. Rail, took time inputting all of that data into these spreadsheets. I mean, it's a substantial amount of data. And they did do all of that stuff. And then they got to the last stage and legitimately believed that it was submitted. And the reality was there was one more button. And I understand, and Utah understands, that these forms are important to the commission. The commission needs them, that they need to click that submit button. But, a reasonable approach would have been for somebody to say, okay, I realize this is a mistake. Why don't we click that button? Instead we've got 40 violations, for this. And so I just wanted to clarify those facts. The other thing that I would like to talk about for the commission is a big policy objective. And this is more related to the commissioners than it is related to this individual docket, but I think it's important. This is not as simple as one penalty. This is an overarching policy that the commissioners want to set. And the policy that we've been told is that the commissioners want to achieve compliance. Well, here you have an operator that their compliance matters so much to them that they have spent thousands of dollars to come before the commission to show the commission what's happened in hopes that someone will look at this logically and see that it was just a legitimate mistake. If that's not a desire to comply, I don't know what is. You know, Mr. Leach has testified it's his reputation before the commission that's valuable to him. You know, it's not about some minor penalty amount. You know, that the commission has achieved that objective. You know, you have a filer who's crying when she received notice that the mistake had happened. That's a desire to comply. Like, that's a legitimate desire to comply. They responded to the NOB one day after they received it. They had phone calls about it the very day on Saturday that they received it. You know, I think the commission can see that they legitimately tried to do it. And so the commission's objectives to want to achieve compliance have been met through the commission's current policy. But what's happening is that this policy is shifting, not from one to achieve compliance, but one to achieve penalization. And this is not related to this docket, but this is a big picture difference. When the objective of an agency or as a parent or any person in authority becomes penalization, and that agency no longer is viewed as being reasonable and in partnership with its constituency, the goal becomes to avoid penalties, not to comply. If you look at these federal agencies that penalize and use no common sense when enforcing their regulations, they don't worry about enforcing the spirit of the regulation, but only the black letter law. The objectives of those particular people that they regulate, it's going to be to do whatever they can to avoid a penalty. That's not what this commission currently has, but that's the direction that this commission is currently going toward if things like this happen. Right now, the commission paints itself as in partnership with its regulated agency. That's a perfect relationship between a regulator and the regulated industry. And when that relationship exists, people will want to comply, just like Mr. Leach is wanting to comply in this instance. But if that changes and the commission is no longer willing to take steps to be reasonable and to try to achieve a fair result, and the goal just becomes, well, black letter of the law was violated, you're penalized, the goal of the industry will be to avoid penalties. Not this particular operator, but that's the natural result. The other thing that I would like to point out is the reason I showed this K.A.R screen to the commission is because I felt like personally I could have easily made that mistake. When I navigated to that system and I uploaded it and I see that it has a submitted date or a created date, logically, it looks to me like there would be either an acceptance or rejection in the following column. Logic doesn't tell me I need to click a detail button that will take me to another screen to click submit. And I understand that this was after the original deadline, but I'm only pointing out that they took efforts to try to comply. They wanted to comply with the regulations. And I would hope that, you know, in looking at that screen, maybe even the commissioners could realize I could have made that mistake. You know, if I were navigating that system, it would have been easy for me to believe it was submitted too. And that's why we walk through that. The unique facts in this case that make this different and that the commission would not have to worry about setting a precedent are, one, that the form was fully complete, fully submitted, uploaded, but wasn't submitted. And the most important factor is that the commission can verify that through the K.A.R system. Like, I've listened to the commission's hearings and other dockets, and I've heard witnesses saying, I didn't receive this piece of mail, I didn't get it, wrong address, I got all the others, but not this one. I've heard all that. That's not what's happening here. That's generally what an operator that blew it off might say. But in this case, your system shows that they uploaded it. It shows that they did all those steps and they uploaded it. And so we're not being asked to believe someone, just to look at what COLAR actually shows. And as for the result that's requested, we're putting in the commission's hands to look at the situation, look at, the policy objectives and set an amount that's fair. I'm not putting an amount in front of you, to accept this or reject this. The ultimate reality is whatever you set, this operator is probably going to pay that. This isn't a deal that we're, trying to argue a legal point. This is simply a policy point, and we felt like if we put that in front of you three commissioners, that you might disagree that this was being handled the way that the commission wanted to see it handled. That's the only reason why we're here. And so we're just asking the commission to look at it, apply fairness, and set a penalty and an amount of violations. We have it in the testimony, but the $5,400 financial assurance, the only way that is avoided is if the penalty amount is below $3,000 and the total number of violations is below 3 in number. So whatever the commission deems as fair, we'll accept that. We're simply just laying the facts at your feet to let you decide. I thank you for your time.
All right. Thank you, Mr. Brock. Mr. Kimbrell.
Thank you. I completely agree with Mr. Brock that this entire dispute basically comes down to a question of policy. Should the commission consider the reasons an operator committed a violation and then use those reasons as an excuse to lower a penalty amount, or should the commission apply its regulations as they are written and assess the penalty amounts as required in those regulations? Staff believes that considering the reason for a violation and lowering a penalty amount would be inappropriate. Just to throw out an example, should a violation resulting from an operator's mistake result in a lower or higher penalty amount than an operator forgetting about a deadline or losing a piece of mail, or should that be a lower or higher penalty than an operator coming down with the flu? It shouldn't matter. Considering the reason for a violation and lowering a penalty amount would mean that different operators would receive different penalty amounts for the exact same violation. And that would be inequitable, and it would be contrary to the plain language of the regulations. And Mr. Brock talks about how applying the plain language of the regulations would mean that operators would avoid penalties. I think that's what we want. We want operators to avoid penalties. If applying the regulations uniformly and consistently means that operators come into compliance, then that's a good thing. So I think the best way to make sure that operators comply with the commission's rules and regulations is to apply those rules and regulations consistently and uniformly, and to treat each operator in the state of Kansas equally. The commission simply should not be in the business of playing favorites. So commissioners, given the facts of this case, staff believes that $4,000 is an appropriate penalty because it's the penalty required under the regulation, under K.A.R. 823409. And so therefore we ask the commission to affirm the penalty amount. Thank you.
All right. Thank you, Mr. Kimbrell. We have concluded closing statements. Just want to tie up any loose ends here with post-hearing issues. It's my understanding that the parties do not intend to file post-hearing briefs. Is that correct?
Correct.
That's correct.
All right. Are there any other final issues the parties need us to address before we conclude the hearing?
Not for staff.
All right. Thank you. Commissioners, any other issues? I'm not hearing anything. All right. Well, we thank you all for your time. This concludes our hearing in this docket. At this time, we will close the record and we are adjourned. Thank you all for your participation.
Thank you.